Hi everyone. Okay, hi everyone again. My name is Harsh, and if you cannot hear me, my volume is too low, or if I'm going too fast, I move through the slide too quickly and you have a question, just unmute yourself and interrupt me. That's okay. I cannot see everyone. I may not see if your hand is up. So if it's more than 15 seconds and I don't acknowledge you, please either Sarah or yourself, just let me know. So moving on, Sarah kind of did a quick introduction, but I'll just repeat it. I'm currently a postdoc at Trinity College Dublin. Not too long ago, I finished a PhD, which is not that big a deal unless you happen to do a PhD, in which case it's a very big deal. And right now I'm chairing W3C groups on data privacy vocabularies and controls and consent. So I'll come to these two a bit later, but I would like to start with FAIR. And I'm hoping that everyone knows what FAIR is, like findable, accessible, interoperable, reusable. What does it mean? How do we use it? How does it enable the data ecosystem to exchange information about what kind of data is going on and what are the conditions to operate it? So if you look at it from this perspective, FAIR is actually all about enabling data sharing, because you use your FAIR mechanisms to find data so that you can use it from someone else, or you can use your own data to be useful for somebody else. So in that sense, FAIR is all about making data more open, making data more usable, creating these data sharing workflows. Now, the problem with this is that legal compliance says, don't do this, don't share your data. Keep your data to yourself, or at least be more responsible with it, or don't just willy-nilly publish everything in the open. There are many things you need to be careful about. And it's not just one law. There's many different types of laws. Like you have your copyright law, where a company might say, or an organization or an individual might say, hey, it's not okay for anyone to freely share this, even if it's fair, even if it's in the interest of someone. I have copyright over it. I own this data. Or there can be privacy regulations that say, hey, don't share this, it might negatively affect someone. Or you have data protection regulations, which might say, hey, don't share this freely unless you know who you're sharing it with, or for what reasons, or you make sure that this data is secured in a certain way. And if this was not headache enough, EU has a whole set of different regulations in the pipeline relating to digital services, data itself, digital markets, AI Act, and the rumor is to be believed dedicated data spaces specific to the health and specific for cybersecurity. I don't know. EU really likes to publish new laws. It's very difficult to keep on top of them. So if you're willing to do fair data sharing and you want to make sure that your legal compliance is up to the date, how do you harmonize between these two? Because what you really want to get towards is saying, okay, my fair data sharing is legally compliant, which means that whatever value you want to achieve or provide through that fair data sharing is legally compliant, which means that you don't have to worry. The user of the data doesn't have to worry. The people whose data it is about don't have to worry. So how do we get to this location is what this presentation is all about. So a brief introduction to General Data Protection Regulation. It's very EU specific, and why I be kind of more EU-centric here is because before GDPR, it was more kind of hodgepodge of privacy and data processing, data protection. But GDPR came along and said, hey, no, wait a second. Here's this really strong concepts. Here's this really strong obligations. And it affected fair data specifically, or rather data sharing specifically, because anytime that data was about a person, that is, it became a personal data, or involved the processing of personal data, this regulation applied. And they were super heavy fine. So 4% of the global turnover, or 20 million euros. So before we kind of get into what these terms are, we need to understand what is meant by personal data. So personal data under GDPR is any data that is about anyone. So it could be your name, it could be your email address, or it could be how many steps you walked today. So anything that is associated with you becomes your personal data. Then what is meant by processing? So processing is anything that you do with the data. You can collect it, you can use it, you can store it, you can share it. If in any way you touch or operate on the data, you are doing processing, and it is covered under GDPR. So how the data is being processed is basically what activities you perform on the data. Transformations, you're training your machine learning network, you are simply sharing a CSV, you are hiring a person to go through and analyze it, doesn't matter. It's still data processing, and all of these are types of processing operations. So who is involved in this? Who is the data about becomes the data subject. Who controls the processing or determines how the data should be processed becomes data controllers. And if they hire somebody else to just do part of the processing, they become data processors. And any entity that is not one of these becomes third parties. So basically, the problem under GDPR is how to check processing is following the rules of the GDPR. If you have some data and you're processing it, you need some mechanism to check whether your processing is following whatever are the obligations laid down by the GDPR. And this is the general template which all of the world's regulations are slowly moving towards. So if you look at any law that has been passed after 2017, 2018, it kind of follows this general template, which means that you have a definition of personal data, you have a definition of processing, you have a definition of purpose, and you have a definition of actors involved in that processing. Now, how does this relate to FAIR? How does FAIR data become GDPR compliant or vice versa? Where to begin? So if you consider your FAIR data as basically data catalogs, which means that they are packaged together, and you slap a label on it that says, hey, this is what the data is about, or these are the actors, the agents, the entities associated with the data. And here's this license under which you can use, share, or enhance this data. The problem is that GDPR uses different terminology because GDPR says you no longer have actors, agents, licenses, but instead of that, you have controllers, data subjects, legal bases, and you no longer have a data catalog or data types, but you have distinctions between whether the data is sensitive or of a special category. So for your FAIR data sharing to become sort of GDPR compliant, you need to have better labels that talk about what that data is about in terms of how GDPR understands it, which means that for FAIR data sharing, for better handling of data under FAIR data sharing, we need a class of better data, which is not available in FAIR data as of itself. Now, before we go any further and go, yes, let's just create another metadata standard, let's put a G in FAIR and call it GDPR compliant FAIR data set and data sharing, there's more complications. Personal data, if you just go by the GDPR definition, is not the same if you go by the ISO definition or if you go by some other regulation definition. So if you only target one regulation, your data sharing becomes entrenched in that jurisdiction or in that law. So if you only target GDPR compliant FAIR data sharing, you're kind of okay-ish in parts of the EU, but anytime that use case involves any actor that is not necessarily following GDPR, such as it's dealing with ISO standards or other regulations or other jurisdictions, then you run into the same problems as before. You have different terminologies, like different notions of controllers, or maybe they're called data responsible entities. You have different types of legal bases, and you have different notions of what is considered sensitive data. So to add to even more confusion, if you say, okay, I can just avoid all of this by anonymizing my data and then sharing it in a data set, be aware that when you say anonymized, it's not necessarily completely anonymized. Because when we say anonymized, it means that there is no chance, not with the data itself, not by combination with another data, that I can re-identify the person. So for example, if I take everyone's names here and I just remove the last name, your family name, I can claim the data is anonymized. But then if I again get this list from someone else, maybe Sarah emails me saying, oh, these were the participants, I can easily match your names back to who was present, which means that my initial list was not anonymized, even if we assumed it to be so. So simply saying that anonymized data, encrypt data, is not an easy solution to FAIR data sharing, because there are exploits such as you can re-identify the data, you can combine, or you can always find some attack on the anonymization process itself. This is a known problem, whereas companies claim that they use the data in an anonymized fashion, but many times it is not fully anonymized. And this has been proven time and again. You take someone's location, you claim that you have aggregated it, but all it takes is for me to collect 5 data points in you. Within a day, over a week, doesn't matter. If I have 5 data points on how you move about, I can easily re-identify you. Same for voting and voters data. All I need is your gender, your age group, and your generic location, and I can re-identify you pretty easily within a voter data set. And fingerprinting, browser configurations, preferences are so unique that you can easily get 30 to 40 different attributes through which you can re-identify a person just when they open the browser. So anonymization is a very weak solution. And even at the end, even if you anonymize the data, it still may remain personal data, which means that your original headache, like, hey, am I GDPR compliant, still applies because it is still personal data. Last headache, I promise. If you process or share any of these types of data in your data set, then you'll basically have a big problem, because these are considered as special categories and they are prohibited unless you do something that is mentioned in Article 9, such as get the explicit consent of that individual, or make sure that you are using these only for scientific research or for public benefit, etc., etc. But at no point is it allowed to use this data as you wish. So now you first have to check whether your data is any of these special or sensitive categories. Now, GDPR defines this list. Other jurisdictions may define any other list. So how are you going to compare everything to everything else? Now, coming back to the FAIR side of things, when you share your FAIR data, you package your data and say, okay, I want to make it findable, I want to make it accessible, I want to make it interoperable, I want to make it reusable. The general question is why? For what purpose, right? So simply making the data interoperable or findable is step one. But the step two is whoever is using that data, why do they want to use it? Is it a company who's simply siphoning all the photographs of the internet, like Clearview AI, and saying, oh, I'll just sell it to the police institutes or to any organization that wants to do facial recognition? Or is it a company that says, okay, I'm going to collect everyone's genetic history and find patterns for diseases? So the difference between that FAIR data being shared for a malicious purpose and a FAIR data being shared for a beneficial purpose is two extremes. So when we get to the notion of why that FAIR data is being shared and who can use it and for what purpose, the notion of purpose is very weakly defined. So purpose can be grouped, such as you can say, okay, you can use this FAIR data for any scientific research, whether it's hospital, medical. You're not going to sit down and construct an entire list of what each category of research is. You kind of imply that, okay, as long as it's about scientific research, it's understood whether it's a hospital or medical institute. Or if you say, use this data however you want, you don't list out any and all categories of however you want. It is understood that however you want does not include taking the data and harming someone, taking the data and blackmailing someone. So these notions of purpose have inherent meaning, which is not captured when we usually share FAIR data. So the licenses that we currently use for FAIR data, where it goes, okay, you may use the data for X, you may use the data for Y, is not the same as legally compliant data sharing, which says that the purposes have to be specific and don't always have to benefit the data subject. So which kind of brings us back to that original problem where you say, okay, there's a difference between how we share FAIR data and how we talk about legal compliance or GDPR compliance. And to put this into perspective, we have a widespread problematic occurrence of companies or sometimes even individuals using the wrong legal basis to use data. So most often than not, companies will try and use consent or legitimate interest as the databases. So if we simply say, oh, let's just share your data as per GDPR's legal basis, and you say, okay, this FAIR data is available under consent or under legitimate interest, it's not enough because you are simply enabling someone else to misuse this data, which means that someone else can just take the data, not collect consent, or collect not valid consent, which means that they basically don't tell you everything or kind of implore you, hey, click on this accept button and give the consent. So simply saying slap a label called consent, slap a label called legitimate interest is not enough. Then there are the other legal bases which are kind of okay, which means that you have a contract, you have a legal obligation, or you're sharing the data for public interest or to protect someone's vital interest, such as someone needs medical attention, or you're enabling your local government to conduct a census. These are kind of non-problematic areas. So the problematic areas relate to consent and legitimate interest. And now what this implies for fair data sharing is that there's a bunch of stuff under GDPR, but I'll only focus on a few of these. So you have a few principles which are super vague, which call purpose limitation, data minimization, which talk about that if you have data, then it should only be limited or minimal to whatever kind of processing you're doing, which is exactly the opposite of fair data sharing. The principle of fair data sharing is make as much data available as possible, right? Because we want to extract more use and value out of that data. If I collect data for an experiment that says, oh, I just want to know how people use the internet, I don't want to limit that to just that single purpose. I also want other researchers to understand how do people use their computers, for example. So it's not easy to align the openness of scientific data sharing or fair data sharing with that of GDPR principles that talk about purpose limitation and data minimization and accuracy and so on and so forth. Same for consent. I give consent for the first time for that data to be shared. I cannot give consent for the data to be shared with any number of third parties, because each of those third parties or other users of data should come back to me and get my consent, unless that consent is very clear or gives enough conditions that the other entity goes, okay, I meet these conditions, I don't need to ask for consent. And this involves creating that transparency, creating notices, providing individuals the ability to object to their data being processed by anyone. And if everything else fails, then you can simply complain to your supervisory authority or data protection authority. So what this means for the FAIR data chain or the workflow is that you need to make sure that you capture the data source or provenance of that data, not only at the source, but at every entity that changes the data, modifies the data, or takes that data forward. So this involves whether you have permission or prohibition from consent or other mechanisms in place. So actor A may have permission or prohibition to use part of the data, but that should not prohibit actor B from using that same data if B can manage to get that permission or prohibition. So this is something that's very tricky to achieve. And if you manage to figure it out, you basically can win large amounts of funding from the EU. Companies will throw money at you because you've solved a decade-old problem. Which brings us all down to today's world, which is adding legal metadata, as I call it, in FAIR datasets. My example is limited to the GDPR, but you can easily expand it to other jurisdictions. I use GDPR because I'm in the EU and I'm more familiar with GDPR. But if you're in some other jurisdiction, just substitute with whatever is the local data protection law. So what does this mean when I say legal metadata? I mean that FAIR dataset has some metadata associated with it, which is how we make the dataset fair. We just add more metadata, which is associated with the legality of the data. And through this, we achieve responsible data sharing. So for this, we take lessons from CC BY, which is a very commonly known license. Everyone knows it, everyone respects it. All jurisdictions know what CC BY means, what CC BY NC means, what CC BY ND means. So if you simply say, okay, this data set is shared by CC BY or whatever is a commonly used license, right? Everyone knows that, okay, they can use it, they cannot use it. So what is the lesson learned here? It means that we need commonly used terms, which I call commons vocabulary, so that everyone doesn't have to do a legal assessment on their own. Like if every data set required you to hire a lawyer, we're never going to be able to share data, right? So it has to be something simplistic that you can just go, okay, I understand whether I can use this data or not. Second, metadata is entirely dependent on the context. By context, I mean whatever is your use case, like you are in a hospital, you're in a medical center, you are in a CCTV operating shop, the domain like finance, again, medicine, or jurisdiction like EU, France, or USA, or maybe some other exotic location which doesn't even have a data protection law. So if that vocabulary is to work everywhere, then it should address all these use cases. And what do? We create such a vocabulary. We use it to express what we call our version of terms and conditions, but for FAIR data. And we stick it to the data like a label, which is called a sticky policy. And we use it to publish, share, and use the data. So not much different from existing FAIR mechanisms where you have a license or where you attach conditions, except that these are more formally defined in terms of how they relate to legal compliance. So instead of creating ad hoc mechanisms for, oh, you can use this data only on Sundays or Mondays, we strictly define you can use this data if you follow this jurisdiction, or you do this equivalent in your jurisdiction. So for example, I can call a policy that says, hey, my data, which is the FAIR data set being shared, has sensitive data attributes. Therefore, you can only use it for scientific research or you're a public institution. Now, it doesn't matter whether this person that is using the data is in the EU or the US or Japan or anywhere else. If they're a scientific research institute as per their local laws, they can use the data. Or if they're a public institution as per the local laws, they can use the data. Second example, your data can only be used for X purposes. So X can be anything. You substitute X for whatever is your favorite purpose, like, I don't know, enhance existing medicine or whatever. And it can only be shared with others in the EU. So now you create restrictions on the data where you say you can do whatever you want, but only if it matches these conditions. So these conditions cannot be complex. It cannot be like in EU unless it has blah, blah, blah. Otherwise, you get into all sorts of problems. So you start with something simple. Just mention one recognized location, shared with others in EU, shared with others in a specific country, shared with others in a specific group of companies, for example. And if you want to share it with others, again, they only use it for X. So now you're creating that data link, that data chain with the same policy. So anytime this company or this person shares the data, similar to the CC BY license saying you have to attach this license to any derivative work you do. So if I take an image and I modify it and I republish it, I have to publish it under CC BY again. I have to share this data again with that original license or policy attached. So this makes sure that everyone who receives that data knows what are the conditions to use that data. Again, not a new concept, has been done many times in research and in industry, but there is no well-known or commonly accepted or standardized mechanism to do it. In FAIR terms, we have standardized what are the conditions or requirements for datasets to be considered fair. In the legal world, there is no such commonly accepted notion of when these policies are considered as fair or shareable, or when the data value chain is considered legally compliant. Now we move to solutions. So this is probably the most comprehensive solution in terms of machine readable metadata, which allows you to express rights and conditions. It is called ODRL. And it basically allows you to express policies which tell you your assets, which is the data, are governed by some rules and what that implies in terms of actions. So for example, you can say that for this data, I express a rule that you have to inform me every time you download the data set or you share the data set. And rules can be of the type permission or prohibition. So I can say you're allowed to use this data and you're prohibited from sharing this data further. It also talks about duties and consequences. So if you use this data, then you have to send me an email, becomes a duty. If you don't send me an email, I can file a court case against you, becomes a consequence. So it covers a lot of what existing contract languages and legal notions of permissions and prohibitions are. But it still doesn't relate exactly to the existing notions of GDPR or to the way data sets are shared. To solve this problem, data use ontology was an effort by medical researchers to create a vocabulary called DUO, data use ontology, to express permissions and prohibitions for medical data sets. And what this means is you have a data set like this, and you express all the things that you want to permit and all the things that you don't want to permit. And it's pretty straightforward, but it only works if your use case lies within these specific categories of data types, or rather medical operations. If you have a use case which is not included in this data repository or conditions repository, then you cannot use DUO. So this is the kind of operation which is great. We want to obtain simplicity like DUO, but we want it to be generic. So what I'm involved in is called the data privacy vocabulary, and it's basically a very generic vocabulary which talks about all the different kinds of data, purposes, processing, legal basis, blah, 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 coming from the legal world. And it gives you a set of taxonomies for each. So this means that for personal data, you have sensitive data, special category data. For purpose, you have different kinds of purposes like marketing, service provision, sell products, research and development. Same for processing, legal basis, technical measures, blah, blah, blah. So when you get DPV, you get a dictionary of concepts. So these all solve different problems. Like ODRL talks about how to express rules. Duo kind of gives you a data model of how to do simple permission prohibitions. And DPV gives you a legal vocabulary of things that are associated with processing and sharing data. So when we combine them all together and you apply to a use case, you get lots of questions. So the proposal here is basically you take your FAIR data set, right? And you attached another set of metadata, which is all of these stuff, which will help people understand and answer these type of questions. Like, is this FAIR data set personal data? Yes, no. Does this FAIR data set contain special categories of data? Because then it has implications that, oh, I should take care when I'm using this data set, or I should take care when I'm sharing this data set. Does this data set represent things that have been collected at a large scale, like everyone's phone numbers, everyone's photographs? Does this have a specific purpose, or does it have a broad purpose? So for example, if the purpose is research and development, it's pretty broad. You can use it for anything as long as you justify the research and development component. But if you say research and development for developing new methods in, I don't know, genetic diseases, then you have a very narrow group of purposes. So labeling specific purpose. You can attach legal basis. So you can say, hey, you have to have consent of every individual, or you have to follow this contract, or you can only use a public interest. So you can only process the data under public interest. And you can define technical organizational measures, which means that you need to have responsible data use policy in place, or you have to provide people notices, or you have to make sure that the data you store is encrypted, secure, blah, blah, blah. And then these are basically all the actors on the right-hand side. Who is the entity control, like doing the processing? Who is the data about? Who are you sharing the data with? Is there a known risk with this? So there's a lot to unpack, and not everything is important. But if you just look at the left-hand side, this is your core bit. And the right-hand side is more that you need to do for legal compliance. So we kind of have a notion of what this label looks like. But then you again run into problems, which is that FAIR metadata is essentially a promise, because how do we make sure that anyone who uses the data does, fulfill the terms of the promise? If I say you can only use this data for X, and someone takes the data and doesn't use it for X, what does it mean? Who is liable? Is it my responsibility? Is it the person's responsibility? So this is where you get into problematic aspects when you combine FAIR data sharing with legal compliance. Not just GDPR, but also copyright-wise. So a possible solution is to not share data sets directly, which are problematic, create a barrier, create an access control barrier in between, where you share only a part of the data set, or you share only the metadata or schema of the data set. Let the actor determine whether it is of use, let them contact you, and basically you create a legally binding contract, so which either says, okay, it's not my responsibility, you take this data under these conditions, or it allows you to basically say that I have given this data on this date and time to this entity, my responsibility ends here. This doesn't have to involve a human, by the way. This is perfectly doable in a machine readable format. And this is what I call the hospital model, because this is how hospitals currently work when they want to partner with companies to do data sharing. They don't just open up and go, come take a look at our patient data. Companies first ask, hey, do you have data about this type of patient that we're looking? The hospital goes, yes, this is what it looks like. The company goes, okay, this is of use. And then they negotiate who is going to use the data, how are they going to get access, are there any issues, etc. So the solution to harmonizing FAIR data sharing for legal compliance is basically adding more machine readable metadata using vocabularies. And I'm not saying these are the only vocabularies, but this is a good candidate. ODRL, I have personal biases with data privacy vocabulary because I am involved in its development. But basically what you want, anything that will allow you to express the kind of stuff that allows you to tick those legal compliance boxes, which means what type of data, what type of purpose, who are the entities, is there a legal basis involved, and you want it to then make it specific for a specific regulation. So you can share your FAIR data in a legally compliant way without directly addressing GDPR. If you simply say collect consent, that's fine. You don't have to say collect consent under GDPR. You then attach the implication that whoever is using this data set has to follow their local laws. So in the case of EU, it is GDPR. In the case of US, it might be something else. If you're not sure whether this should be allowed, you want to say, no, it has to be according to GDPR. Only then you say, okay, use consent, but follow the notion set by GDPR. So in defining this machine readable metadata, the first level is the rules, the second level is the legal, and then the third level is the specific law or jurisdiction. So in this way, the data is still findable, accessible, interoperable, reusable, because you have different layers under which someone can assess whether they are compatible with using that data or not. And this is what data value chains and this whole new notion of how do we enable sharing of data is all about. How do we create this left half bottom layer of vocabularies and concepts that allow people to match their data compatibility between not just FAIR, but also purposes and so on. So when you're talking about legal compliance, we are trying to say, do your legal compliance in a fair way. So your FAIR data sharing has now become FAIR legal compliance sharing. So you're sharing metadata about your legal compliance in a fair manner. And the key takeaways from my talk basically are that these are all open challenges. I don't have a fixed set of solutions. I have very good directions that are very promising. They work, but nothing has been finished yet. And these are basically, one, there is no set of legal requirements for how data sharing should take place, again, relating to FAIR. So there's nothing that says if you have a FAIR data set, what kind of legal requirements that FAIR data set has to follow, like if you follow the typical FAIR data sharing workflows. Second one, if you do that and you have your FAIR workflows with legal requirements, then which laws and which jurisdictions? If you only follow one law, what happens when it is shared beyond that law or beyond that jurisdiction? So the first two are problems. The second two are solutions. So we want to create machine readable vocabularies or policies which go from generic to specific. So it's the same as saying, how do we enable FAIR data sharing? We create machine readable vocabularies which help make us data FAIR. Similarly, we want machine readable vocabularies which make our legal compliance FAIR, and we want them to be generic first and then specific for laws, so that someone else using that data in some different jurisdiction or use case is still able to use that data and kind of align it with whatever their use case or legal compliance requirements are. And based on this, we want to develop new FAIR workflows based on legal actors policy. And this has to be as simple as simply saying, I publish my data with this legal license, and someone else can just find that data based on saying, I'm looking for data usable under GDPR consent. Okay, here's the data. So your existing FAIR workflows have to support legal actors and policies for that FAIR data sharing to become legal compliant. And that's basically all the key takeaways and messages that I have. Thank you. I think we can open the floor for question and answers.
Yeah, I'm going to stop the recording here. Thank you so much.